Ayan Hamalio, Ahoyet, Tisdale, Dewito Notet. I said, hello, my friends. My name's Red Eagle, and it's nice to be here with you today. I'll be sharing on what is meaningful tribal consultation. And I'll go ahead and share my screen. Um, it should be visible now. So there's a lot that goes on with consultation, a lot of different perspectives and expectations. So I just wanted to kind of discuss that a little bit. But as I mentioned, my name's Ethan, Ready Go Lawton, here at SHN, Tribal Liaison and a planner. I come from 4 different nations, a quarter Inupiaq, which is Alaskan, a quarter Navajo, a quarter Sioux, and a quarter Thona'atam, which is the tribe I'm enrolled in as a member. Quite a bit of experience working with different cultures and many tribes throughout the nation, and kind of newer-ish to planning. It'll be 9 years. And so, yeah, a few disclaimers before I dive any deeper. Whenever I mention tribes, I'm not speaking on behalf of all tribes. I'm not a lawyer, so I'm not providing legal advice, just educational purposes, and in no way am being political in any way. In context, this is a simplification overview. This presentation discusses the tribal consultation purpose and outcome, specifically on tribal cultural resources during the AB 52 process. I'll cover what meaningful consultation is, according to CEQA agencies and most tribes. And I'll also cover the potential amendments to AB 52, and then followed by questions and answers. So what I'll also include in this presentation is a court case. We had our first court case on AB 52, and a lot of this kind of overlaps each other on what is meaningful. So meaningful tribal consultation, again, there are different perspectives, different expectations. Agencies often see the consultation as part of the process, maybe something to check off the box, to reach out and to consult. Tribes often see this as an opportunity to participate and be involved in the process, to contribute to the analysis. Developers often see this as a time constraint. Public also sees this as important in regards to the protection of resources and values. And of course, there's CEQA law. There's projects and tribes, and there should be a relationship between the lead agency and tribes, and the AB 52 process is supposed to outline all that. Also, I just want to mention that keeping time in mind, there's going to be a lot of information in this presentation. So you might get a little overwhelmed on that, but I want to dive into the court case real quick. And the court case happened on March 14th, 2025.
Screen being shared.
Yes.
Got notice that it isn't being shared.
So I just got notified that the screen is not being shared. I think it's being shared now. Okay, confirmation. Screen's being shared. So the consultation court case happened on March 14th, and it was the Court of Appeals, and it was between the Khoi Nation and the city of Clear Lake. This court case shows that it's the first published opinion interpreting AB 52, and the court determined that the city failed to engage in meaningful consultation. So it's actually kind of good timing with this presentation on what is meaningful and what is not. they determined it was not meaningful because the result was invalidation of project approvals. And this was for a 4-story hotel with a road extension. And it just shows that AB 52 is not procedural, not just procedural, but also substantive. So it's not just a check in the box, it actually has to have some meaning in it as well. And so there needs to be clear communication and thorough documentation and demonstrable efforts. What happened was that the coordination requested formal consultation, and the city representative attended the initial meeting, but failed to document this in the administrative record. And then following that meeting, the tribal representative submitted a letter requesting some mitigation measures, and the city did not respond to this letter, nor did they continue consultation. Instead, they adopted the MND and only incorporated one of the recommended 3 mitigation measures, and then provided no documentation on how that decision was made. So that's kind of how the process went. And then the court rejected the city's argument that the general coordination efforts involving everybody, nor the consideration of archaeological surveys was sufficient for AB 52. In other words, there needed to be a specific consultation between the lead agency, the city, and the coordination, the tribe. The court emphasized that consultation must be meaningful and directed towards seeking agreement, and it must be all in the administrative record. So this, their administrative record that they submitted to the courts was deemed not sufficient and did not support the city's determination to terminate consultation. So that was the findings of this court case. The court distinguished between informal discussions held outside of AB 52 and formal consultation required by AB 52. So there's a clear distinction between formal and informal, not so much as important and non-important, but within the parameters of AB 52 and not. So while the court acknowledged that the correspondence between the tribe and the city was not as formal as it could have been, it concluded the city's reliance on that was no excuse for the failure to engage in the mandated process of consultation with the tribe. So with that finding, the consequence of the case was that the court vacated the city's MND and all approvals associated with the project. The court further ordered that consultation must recommence according to AB 52. So not only was everything peeled back, but they had to restart where things left off in the consultation process. And then notably, the tribe did not submit comments on the draft MMD, but during public comment review, but requested consultation. And that seemed to prove sufficient to preserve those claims within the AB 52 process. So it just goes to show how important the AB 52 process is in the consultation between the city and the tribe, and how it needs to be meaningful and substantive. So some takeaways is this decision signals that lead agencies must treat consultation as substantive and confidential as part of an intergovernmental dialogue, not just checking the box exercise, not just procedural, but substantive as well. And agencies must prepare all of this within the administrative record. That agreement was actively sought, and that there must be a good demonstration of good faith and rationale for any decisions. And so really the administrative record should contain all of that agreement, good faith, and rationale. And another takeaway is that all this should be summarized in a sealed appendix. And that's what happened with this case. Was there was a sealed appendix and it was handed over to the courts. And that's where the court made all their review and findings. So for lead agency, keep good records of everything and act in good faith and reasonable effort. For developers, it just reinforces the importance of early and continuous engagement between the lead agencies and tribes. Incomplete consultation records may result in significant project delays and may turn over approvals. So it just goes to show how important to keep a good record of all this is. For tribes, it also reinforces the importance of communicating the potential impacts and mitigations, and to not shy away from that, even if you don't hear from the lead agency. So some best practices to keep in mind with AB 52 is I'm sure everyone's familiar with the process. During the drafting of the environmental document, there is a AB 52 process where you reach out to the tribes, and the purpose is to avoid impacts to cultural resources and tribal cultural resources. The process, I always say, is something like this. There are 3 different parts. There's the pre-consultation meeting, where you figure out the consultation process and meetings, the project presentation, the project impacts, and the project mitigations. So the initial meetings is where you figure out the consultation process as a whole. What is the timing? If finances are involved, the location, who's facilitating the meeting? Is it at a formal location? Is it in the field? Is it informal between staff or between government officials? Figuring all that out beforehand can really address any confusion throughout the consultation process. The second part, or the first part, would be the lead agency responsibility of communicating the project as a whole. So the draft scope, the maps, the description, the timeline, really communicating to this tribe the potential impact to, or the project as a whole, so the tribe can take that and analyze it. Then they come back during the second part, and the tribes convey to the lead agency what the potential impacts are. It could be a cultural resource, tribal cultural resource, keeping in mind sacred sites, historic properties, trust assets, and anything of that nature is communicated to the lead agency, both the significance of that resource and the potential impacts. Then the lead agency comes back with some potential mitigation measures. The tribe also comes back with some potential mitigation measures. These mitigation measures are discussed and hopefully agreed upon, or agreed to disagree. There's standard mitigation measures, there's some creative ones, and project alternatives can also be considered. Feasibility is analyzed and discussed. So this is the time where all of that's put out, and there may even be impacts from the mitigation measures that need to be considered as well. So that's where it's all discussed, and then consultation concludes either by agreeing or disagree out of good faith and reasonable effort. And again, all of this should be documented. And I've always encouraged the tribe or the lead agency to get a letter stating that consultation has either concluded or it has not concluded, and based on what items are still outstanding, and whether agreement was reached or disagreement was reached. With that, again, the AB 52 process just goes to show the light green is the lead agency, the dark green is the tribes, and through the process, kind of the roles and responsibilities shift throughout the process, regarding the project concept, the description, the impact, and the mitigations, and then hopefully it's all agreed upon. Some mitigation measures are avoiding, minimizing, rectifying, reducing, and compensating. And it's determined by qualitative and quantitative threshold. And again, all of this should be discussed within consultation as well. There's a lot of significant overlap with best practices and the upcoming potential amendments to AB 52. So I just envelop those into this overview of the potential amendments. Right now, it's still in committee. It was introduced, and the way it's drafted right now is it may be potentially effective March 1st, 2026. It's easy to find. I just search AB 52 amendments and use LegiScan. And it's about 29 pages when I printed it out on the amendments. And that's what this, the rest of the presentation is based upon. So there are minor amendments. Many of you are familiar with the office name change of planning and research to land use and climate innovation, including electronic records, switching out gender language, and so I would consider those minor. Then there are some significant amendments. One of them is addressing tribal classification. So the way it's currently written is there's an emphasis on federally recognized and non-federally recognized, and how they're both developed in the California Native American Tribe, or CANT. However, the state's kind of flipping that and saying that it's California Native American Tribe that is federally recognized or non-federally recognized. It may seem a little minor to you, but it's a significant hierarchical classification in my mind. And that's also reinforced by additional potential amendments, including the very clear distinction of federally recognized and non-federally recognized. Some of that comes in really strong language between the two federally recognized tribes. There's language like unique legal and political status, and unique and legal political relationships between federal agencies, other governments, and with specific rights. Non-federally recognized tribes are described as they may participate by the discretionary decision of the lead agency, as opposed to shall participate with federally. And non-federally, there are some additional language that their participation shall not in any way diminish or alter federally recognized Indian tribes' rights. And even the non-federally recognized tribes' participation is not deemed government-to-government consultation. That is a right by the federally recognized tribes and not the non-federally recognized. So there's some really unique language and different classifications coming up through these potential amendments. And these terminologies are furthered by additional terms like federally recognized tribes being described as sovereign nations with an inherent right to self-govern. while non-federally recognized tribes are even described as a tribal group. So again, seeing a very clear distinction of those two categories within the consultation process. And it's highlighted numerous times throughout these potential amendments that the non-federally recognized tribes' participation in the consultation process shall in no way infringe upon the federally recognized, that the federally recognized shall be afforded deference over other tribal groups that are not federally recognized. So we see this high distinguishing of these two categories. And I'm assuming because the state tries to treat them the same and the federal government has a clear distinction, maybe there were scenarios where non-federally recognized tribes were interfering with the rights and privileges of federally recognized tribes. Maybe federally recognized tribes felt like there was not enough of a distinction of treatment between them and non-federally recognized tribes. But either way, it's kind of a reinforcement of the federal rights trickling down to how the state views and treats these two categories. With that, there are significant changes to the Native American Heritage Commission. Not only do they maintain a tribal contact list, but now they are to administer it, having more involvement in that revisions and distribution of it. And so this also includes the California Sacred Lands file. This was created in 1979. And there's kind of a distinction of categories within this file, not only for tribal cultural resources, but also even of a religious nature. So we're starting to get more of an inclusion of tribal religious practice and rights and preservation of that. And that's scheduled for January 1st, 2027. The Native American Heritage Commission also is to verify the Sacred Lands file with all tribes by July 1st, 2028. And then the Native American Heritage Commission also is to play more of an active role in reviewing regulatory and statutory protections and being involved in that process. And also they are tasked with the delineation of lands and geographical areas of where tribes are culturally affiliated with. So we see they have all these new tasks and responsibilities that are being delegated to them. The Sacred Lands file, they are to review all the inventories, catalogs, findings, and actions, and kind of compile and maintain all that. And these are to provide a baseline to address cumulative impacts. So that way it makes it easier to analyze across time what the collective impacts are. They also are to provide recommended monetary incentives for local governments and landowners to preserve tribal cultural resources. Not only that, but they are playing a more active role with the state's actions and providing recommendations as it relates to sacred lands. And not only that, but they are to notify all landowners of Native American graves and cemeteries with the most likely descendant California Native American tribe. So as of right now, landowners may or may not know, and the Native American Heritage Commission is going to play more of a proactive role in notifications. There are some changes to AB 52 purpose as well. The Native American contact list is for the purpose of consulting with, and additionally, obtaining tribal information and tribal knowledge. So not only is it for consulting, but obtaining that information, which tribes are viewed as being the experts in. Not only that, but AB 52 is not only for preserving and mitigating impacts to tribal cultural resources, but also identifying and evaluating. That should have been part of the process before, but they're really stressing that component now. Tribes have the most expertise concerning tribal cultural resources and identifying them on what they are and evaluating the significance of those resources and the potential impacts. And again, really stressing the obtaining and applying the tribal information and tribal knowledge on the lead agency. So the lead agency is supposed to take that information from the tribe and apply it to that environmental document. AB 52 is now being officially recognized as a government-to-government consultation, whereas before tribes could elevate it to the government consultation. What I mean by that is prior, it was typically staff to staff level with the cultural resource expertise. And it could have been elevated to government official to government official. But now AB 52 is considered government to government consultation, maybe not necessarily as government official to government official, but as a government entity to another government entity. And it should be treated as that government to government consultation. So with that, it means it's more official, more formal in that sense. And so we see that language added officially with this potential amendments. Some clarifications within these potential amendments are traditional lands is also being labeled and as culturally affiliated lands. It could be minor, but I see it as more if you're analyzing the cultural resources, then you have some cultural affiliation. So just some clarification on the authority and expertise that tribes have affiliated with those lands. Tribal cultural resources are being expanded into including what it could be. Again, prior to AB 52, it was just archaeological. With AB 52, it included tribal cultural resources, and with these amendments, it expands even more to include more cultural, more spiritual, and more essential resources to the tribe. And these are tied to the traditions, heritages, even present day practices, and even the identity of the tribe and members of that tribe. So we see an expansion of what's considered a tribal cultural resource, or at least a clarification of that. Native American cemeteries and burial areas are now considered or will be considered with these potential amendments as a tribal cultural resource. So before, these were kind of analyzed a little bit, especially under the paleontological section of CEQA, but it's now being included within the tribal cultural resource section, which means there'll be overlap. Technically, there are some overlap already. For an example, cultural landscapes could be included within visual resources. Paleo or biological resources or plants significant to tribes could be included in those resource sections. So there's always those overlaps to consider as well. Additional clarification that is provided is the identification and determination of tribal cultural resources. So again, it's no longer preservation and mitigation only. It's also identification and determination. And again, that's based on the tribe's expertise. And it's also stressed that the consultation includes identification of mitigation measures as well. Not only that, but any standards, methods, and measures involved in tribal cultural resources should be included and implemented as part of this potential amendments that may go through. Not only that, but tribes are also invited to participate in consultation as early as the type of environmental review necessary for the potential project, and is extended as long as implementation of the mitigation measures. So we see the window of tribal consultation expand earlier and even later than what is currently in place. Some clarification of that timeline is that tribes shall be afforded the opportunity to participate, even as early as the project scoping, before the initial study and before the environmental review documents are drafted. So we see that, again, that beginning of the consultation process get bumped up early. And again, as I mentioned earlier, including the type of environmental review necessary. Language included is even as early in the planning process. So we see the more earlier, the better the consultation happens. And we see that included in these potential amendments. And again, the consultation process is extended to the implementation of mitigation measures. I'll talk a little bit more about that when I address the conclusion of that, which is in a couple slides. But there's also clarification on what consultation means. Before, as it is right now, consultation should have been determined by both the lead agency and the tribe and figuring out what that means. But with these potential amendments, it's further clarified in seeking, discussing, considering carefully the views of others and taking into account cultural values. Again, it's clarified as a formal two-way government-to-government consultation, and it kind of cements that formal process. Tribes are described as part of their sovereignty, and the lead agencies have deference to federally recognized tribes as having expertise with the tribal cultural resources. And it stresses the confidential component and really gives a venue for the lead agency to add on additional confidentiality throughout the consultation process. So we see this real beefing up of what consultation means and clarifying and outlining what it means. Not only that, but the potential amendments also clarify what is not meaningful consultation. Consultation is not meaningful if the tribe is not provided with requested technical information revolving around the project, and that includes administrative drafts of the environmental documents for their review, and they could provide feedback and comments concerning that. Focus on the protection of the tribal cultural resources. And so we see on both sides of the coin clarifying what meaningful is and clarifying what not meaningful is as well. Then we get clarification on mitigation. There's a real tightening of the belt. As it is right now, the parties may propose mitigation measures, and with the potential amendments, we see that change to shall propose mitigation measures. We get another shall consider feasible mitigation measures to shall include feasible mitigation measures. So we see this real hardening of the language revolving around mitigation measures throughout the consultation process. The consultation process is being described through these potential amendments in 2 steps. The first step concludes when both parties agree to mitigation measures to avoid or mitigate potential impacts to tribal cultural resources. As of right now, that's kind of where consultation ends. And the potential amendments solidify that either party shall provide in writing a notice that consultation has concluded based on agreements or non-agreements. And so that's the first step. Then the second step concludes or is completed when the mitigation measures are fully implemented. So we see this distinction between the 2 steps and the increase furtherance into the fully implemented mitigation measures, and that's when consultation ends. So in other words, consultation still continues through the project construction and implementation of the mitigation measures. And the potential amendments kind of solidifies that the mitigation measures are an enforceable agreement between the 2 parties, between the tribes and the lead agency. And it also reinforces that avoidance and preservation in place should be the default consideration of any mitigation consideration. The mitigation clarification continues that if avoidance is demonstrated to be infeasible, and again, that emphasis on demonstrated, the lead agency has the burden of proof to demonstrate why that avoidance is infeasible in order to consider any further mitigation measure action. And with those additional mitigation measures beyond avoidance, it should be treated, the tribal cultural resource should be treated with culturally appropriate dignity and using tribal cultural values. So again, reinforcing how the tribe has that expertise and the lead agencies to defer to that expertise on treatment. Additional mitigation measure clarification is that with the tribal cultural resource, if it's found, they may relinquish ownership to the California Native American tribe. Reburying and relocating the tribal cultural resource is another consideration, and the California Native American tribe access to that cultural resource that's preserved in place for cultural practices, continued heritage teaching, stewardship, and even co-management is considered an option. So we see this real codifying of these different options and really stressing the avoidance and preservation in place. And anything beyond that is deferred to the expertise of the tribe in the treatment of that. As we start to wind down these potential amendments, I want to stress kind of 2 more things, and one of them is the Native American remains. We see a real strengthening of language revolved around the Native American remains. As it is right now, the landowner may engage the most likely descendant, the tribe, on the next action of those remains, but with the potential amendments, it's switching from may to shall engage with the most likely descendant, the tribe. And with that, additionally, the landowner used to consider cultural treatment, but now they shall include cultural treatment. And the discovery may be asserted, but now shall be asserted using tribal cultural standards, methods, and measures. So again, we see this elevation of the tribe's expertise in treatment of that resource and remains. A strengthening of preservation and avoidance and preservation in place, including open space preservation with an appropriate buffer to preserve in place. Consideration of open space or conservation or easement for the preservation of the remains. Not only that, but it's codified now that a record should go to the Native American Heritage Commission as well as to the county in which the property is located to maintain those records of Native American remains, whether it's an individual remain or a cemetery in that place. So with that, I'll kind of wrap this up with what to expect next. Also included in these potential amendments is by July 1st, 2026, they want to update Appendix G to really stress the government-to-government consultation roles, responsibilities in regards to discussing, identifying, determining the significance of tribal cultural resources and mitigation. They also stressing identifying and evaluation of tribal cultural resource, again, with major deference to tribal information and knowledge. And that will be included in that update to Appendix G. With that, even the mitigation measures should be culturally appropriate, again, giving deference to the tribe on their expertise. They will also want to include accidental discoveries in addition to inadvertent discoveries, especially as it pertains to Native American remains, and even giving the California Native American tribe the evaluation. Before, it used to be the coroner, it used to be even the project manager, but it's really driving and emphasizing that tribal involvement and determination. And again, stressing the tribal information, this update will stress how the answers to any and all of the potential impacts to tribal cultural resources are to be answered by the information provided by the tribe. So again, we see this real stress of how the tribes are the experts and how that should all be included within the consultation process and documented within the environmental document and the confidential appendices as well. So with that, we see the updates include, the potential updates include clarificationing, strengthening of language, real clarification of terminology and process. And so that's the direction that these amendments are heading. They may change by the time they, get to a voting scenario. But I just wanted to communicate the potential amendments as they are right now. And it really shows the best practices that could be included now prior to those amendments being voted on. And then just showing how meaningful consultation kind of encompasses a lot that's not fully covered by AB 52 as it stands right now. So with that, thank you for letting me share a little bit about the court case, some best practices, and an overview of the potential amendments. Right, I'm available for any technical questions. We have about 13 minutes for Q&As, and I'll probably stay a little bit late for those who can't stay later to answer any additional questions. So with that, I'll hand it over to Bob for any questions.
Okay. See what questions we have. Go ahead. I can't read those.
All right. First couple questions are about the PowerPoint. Question from Anonymous. Can tribal comments in the consultation be exclusively regarding natural or built environmental impacts such as hydrology or traffic? Traffic, I'm not quite so sure. But hydrology, I would assume yes. If there's any potential impact from the tribe or any adverse effects, should be discussed. And it's up to the tribe can share as much as they want to the lead agency. The lead agency makes the determination to include that in the analysis or to provide documentation why they did not include it. That's what I would encourage the lead agency to do. And so in answer to that question, yes, the tribe can comment on those within the consultation process as it pertains to tribal cultural resources. That's what the consultation is for, is the TCRs. Next question is, do you see tribal consultation occurring for all CEQA documents versus only negative declaration, mitigated negative declaration, EIR? As of right now, only for the EIR, technically. I would encourage all the above. And with the potential amendments, it would be for all the above. And best practice is to at least send a referral to tribes for potentially identifying the significance.
The categorical exemptions still do not require consultation, according to AB 52.
Correct. And same with notice of exemptions as well. But again, best practice is you could send a referral, depending on the location and scenario of the potential project. Next question is there a clear definition on when tribal consultation is necessary? Ground disturbance projects only? And what would be considered ground disturbance? To what extent would placement of a structure on top of earth be considered ground disturbance? Great question. I was involved in a sensitive project that dealt with this distinction. The way AB 52 is written right now, it'd be ground disturbing projects. The way potential AB 52 amendments is any ground disturbing activities associated with the project. So there is a distinction with that. And I don't know if I could provide a definition for what's considered ground disturbance, but I would say it's on the lead agency to document what they consider ground disturbance, and their discretion on why they did not consult with tribes as a result of that. Best practice would be just to at least reach out to the tribes and to see if they want consultation. Next question is anonymous. Do you know how state recognized, non-federally recognized tribes will be included in the new AB 52 process? With the new potential amendments, the lead agency has the discretion to invite non-federally recognized tribes to participate in the review and comments of potential impacts. They're not afforded the same full suite of consultation process of identifying, determining the significance of tribal cultural resources, and providing mitigation measures. With non-federally recognized tribes, the lead agency may invite them they may consider their comments and incorporate them. They may include the mitigation measures. So we see a real difference with that, with the potential amendments. As of right now, current AB 52, the lead agencies that treat both federally and non-federally the same. And so until those new amendments are adopted, there would be that distinction between federal and non-federally recognized tribes. Question on the slide on Native American remains. The first point says landowners shall engage most likely descendant. What does that stand for? Typically when remains are found, as AB 52 is currently written, they are to contact the project manager. Project manager contacts the coroner, the county coroner. The county coroner contacts the Native American Heritage Commission. The Native American Heritage Commission provides the most likely descendant. They contact the property owner and they discuss what they are to do with the remains. So the most likely descendant is the tribe in which that remains would belong to. And so with the new amendments, they are required to engage with the most likely descendant, the tribe, whereas the way it's written right now, the landowner may discuss the remains with the tribe. Question from next is, are changes proposed to align or clarify between federal traditional cultural places and tribal cultural resources? The traditional cultural places are, I think, a terminology from, yeah, I want to say federal agencies. Tribal cultural resources is a CEQA term, so a state term. So there are some differences between the two. And I don't think there's an aligning between those two different terminologies. There is clarification on tribal cultural resources, and I think there's some overlap. But I think tribal cultural places are not as broad as tribal cultural resources. Next question. Will the timelines for notifying tribes and the responding to confirm consultating be the same? Yes. So as of right now, the lead agency has 30 days from complete application, or I think 15. I'm blinking on that time, to contact Native American, to contact the tribe, and then the tribe has 30 days to respond. And once the lead agency receives the 30-day notification from the tribe, the consultation has to begin within 30 days. And then there's no conclusion unless you agree or disagree. So those timelines will remain the same. There's a different timeline for state agencies. State agencies, I think, have a 10-day, 5 or 10-day window in which they are to reach out to tribes. Oh, I also wanted to stress that before, the way AB 52 is currently written, lead agencies maintain a contact list, and I think with the potential amendments, it's all being deferred to the Native American Heritage Commission. And so we see a difference in the notification process and who to notify, potentially. Next question. For some actions and CEQA exemptions, there is language for tribal consideration outreach as part of exemption. Is this a formal or informal outreach? As of right now, it would be formal outreach because it's codified in the outreach process. Informal just means it's beyond what's codified. That's how I interpret it. Sometimes tribes view formal as important and documented and informal as non-important and non-documented. That is not the case. If it's codified, it's formal. If it's above and beyond out of that spectrum, then it's informal. Next question. In a CEQA document, I've always get mixed up about to include in cultural resources versus tribal cultural resources. What are the correct items to discuss in each of those sections? AB 52 consultation background and discussion, tribal referral comments, mitigation measures, should those be under both sections or just TCRs? Should the two sections reference each other? I've heard they shouldn't. Any guidance would be helpful. Yes. Sometimes lead agencies include both cultural resources and tribal cultural resources under the same section in the environmental document. However, they are analyzed individually as in the checklist. I've encouraged the separating of the two and consider that best practice. With the potential amendments, it will be required to be separate sections. And with that, sometimes there's overlap. Cultural resources is becoming more and more archaeological in nature, and tribal cultural resources are becoming, was intended and being clarified more as relying on the resources deemed significant by the tribe, which may or may not have an archaeological or historic component to it. So cultural is historic and archaeological, paleontological in nature. And so we see this distinction with the potential amendments. And I say there should be a distinction as best practice as current today. Next question is, how often are we to ask for updated tribal lists from, I believe that's supposed to be the Native American Heritage Commission. The way it's codified is every time you have a project to consult on. The reason for that is the Native American Heritage Commission analyzes the potential project and determines a specific range. Sometimes it's small, sometimes it's very significant based on the potential project. So it's project-based, project-specific. And with that, it's 1 o'clock. So I'm going to say thank you for, again, your time, and appreciate you listening and asking questions. And feel free to call me or email me with any additional questions, and I'll have it handed over to Bob for any closing comments.
Just one comment was that we will include Ethan's email when you get the thank you for attending. So feel free to contact him if you didn't write it down before that. And with that, we'll thank you for joining us, and we'll see you next time.
Thank you, everyone, and we'll stop